I know that the five of us here who teach con law woke up with an extra smile on our faces. We just love this Constitution. At least I'm speaking for myself. I do indeed. So today is National Constitution Day, and we thought we would celebrate it with just a conversation among the faculty who teach con law here. And I don't teach con law here. I wish I had more time to do so, but I do love teaching con law, so I'm sort of counting myself among the faculty, but I'm going to ask the current folks who are teaching con law just a few questions just to talk about the Constitution, and obviously we welcome any comments that anyone else has or questions. But it's going to be, as I was describing, sort of loose and casual. And I'll actually start out with the context of that we are actually teachers of the Constitution, and we teach cases. So the first question I'll throw out, and I'll start with Professor Lanctot, and then we'll go across for this first one. Tell us your favorite con law case.
Well, happy birthday, Constitution, and it's like being asked who is your favorite child in some respects. So you never want to say and disfavor the others. But I'm going to go with West Virginia Board of Education versus Barnette as my favorite case. Possibly I just stole Twan's favorite case. So you should have sat here. And maybe it's a con law favorite for a number of reasons. For those of you who are not familiar with West Virginia versus Barnette, it's the flag salute case decided in the middle of World War II, in which the court struck down a requirement that children salute the flag or be expelled from school. And it's a ringing endorsement not just of the First Amendment, free expression, but for me, it's always spoken to what I understand the Constitution to be, which is protection of individual rights, and particularly the fact that this case was decided during wartime, and yet, unlike most wartime cases, it upholds civil liberties, is very endearing to me. And because it's by Robert Jackson, of whom I'm a big fan, I'll just give you the two sentences, which Twan probably has in his pocket as well, from West Virginia versus Barnette. And they're very well known to the con law folks. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend upon the outcome of no elections. And then, even more famously, if there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not now occur to us. Our country is great because of its Constitution, not in spite of it. And Robert Jackson's words have been reiterated by many courts since then. And so I know we're supposed to keep things light and breezy, but I don't feel that light and breezy about the Constitution these days. And so I will say that I think we should always keep in mind the memorable words of Robert Jackson. And so I know you all thought I'd pick a Dormant Commerce Clause case, but actually West Virginia versus Barnette is the one that I have on my wall.
So Barnette was my choice for individual rights cases, but the reason I thought I would mention it was to be a little bit ironic, because Senator Byrd is the one who brings us here today, late Senator Byrd, who compelled us, notwithstanding the guarantee against compelled speech, to gather to talk about the Constitution and to praise it too. I think it's like not only with respect to subject matter, but also its viewpoint discrimination. So I'm not acting in conformity with Congress's action, just consistent with it. And I would cite Barnette. But in terms of other cases, the other one would be what would be known to you as the Nixon tapes case. Right? So Nixon versus the United States. And the reason why I like that case is because the Nixon administration, I think, wanted the court to do its dirty work for it, and wanted them to quash the subpoena, Deuces Takem. And my understanding of the case is that the court basically cited the fact that there was still a regulation in place that the president had the capacity to rescind that kept the special prosecutor in place. So the court, both as a deft political maneuver showing its unity, shifted the burden back onto the president to do what was always the president's prerogative to do, which would be to rescind that regulation and then subsequently have the political blowback of having just engaged once more in another Saturday night massacre, whatever day of the week it would have been. And so I disagree with the idea that the presidency is non-unitary, but I do think that in light of this narrower ground of reasoning, that it was a politically astute move on the part of the court.
Great, thank you.
Are you going to say your favorite case or not?
I'm moderating here. I'll see what I get to say.
Well, it's hard to disagree with those, and there are so many others that went through my mind as I was thinking about this. Obviously, Brown versus Board of Education, Marbury and McCullen from the early Republic. I also thought about, speaking at length about Mccullen versus Coakley, because I direct a center here named for Eleanor Mccullen, who was a successful free speech plaintiff, 9-0 in a protest case. But I decided to go even a little more obscure and cite a more recent case that I've often used in the Justice and Rights class, which Professor Brennan also teaches sometimes, and that's Medellin versus Texas, which many of you probably have never heard of, but it's a case about whether or not judgments of the International Court of Justice can be enforced against states with regard to criminal procedure and criminal law. And I think it's an interesting and important case about the states, about the balance of federalism, about the relationship among the international law, the federal government, including the power of the presidency, and the states. Texas prevails in the case. It's whether or not a Mexican national who was denied access to the legal advice of the Mexican consulate could be prosecuted and subject to execution. So the underlying facts are to say the least, unpleasant. But as a question of structural constitutional law and questions about sovereignty, which is one of the themes that we talk about quite a bit in the Justice and Rights class, and which I think are important as a matter of political and legal theory. I think Medellin versus Texas is, among the cases of the last 10 or 20 years, a somewhat neglected classic. So your homework for Constitution Day is to read Chief Justice Roberts' opinion in Medellin versus Texas and Justice Breyer's dissent, which is quite powerful and reasonable, and make up your own mind about what you think about that case.
Good afternoon. I was tempted to choose as my favorite case the case that everybody loves to hate. That's called Lochner. But I decided instead to choose a 1991 case, also not one that would rush to mind necessarily, called Washington against Glucksberg. The majority opinion was written by the Chief Justice. And in that opinion, he undertook what we might call a restatement of the contemporary doctrine of due process. The case came out of the state of Washington, which had criminalized causing or assisting suicide. Glucksberg, who was challenging that prohibition, won in the district court. The U.S. Court of Appeals for the Ninth Circuit overruled the district court. The panel decision by the Ninth Circuit was in turn overruled by the Ninth Circuit en banc, and the en banc decision by Judge Reinhart of the Ninth Circuit was in turn overruled by Chief Justice Rehnquist in the Supreme Court. What Chief Justice Rehnquist said, in going very self-consciously back to first principles about how the court should go about deciding what, not how, what is protected by the 14th Amendment, articulated what we call the careful description and deeply rooted in our nation's history and tradition test. And so the question, as you know, always faced by a court called upon to determine what liberty, what property, or what life is protected is to determine where to look for answers to questions about definitions of liberty and property. And the Chief Justice gave us a test in Glucksberg that was deeply aware of the difficulties of deciding in a fair, even-handed, but not deliberately static way what liberty interests and what property interests would be determined to be protected by the Constitution. And so Glucksberg is a favorite of mine because of the Chief Justice's comparative success, in my view, in setting out an honorable, workable test. But it has a personal appeal as well because the decision ultimately vindicated in the Supreme Court, in the Chief Justice's opinion, was decided by the judge for whom I clerked, not while I was clerking there, but Judge John Noonan. And in Judge John Noonan's opinion for the Ninth Circuit, he held that to hold that the right to liberty, as understood in cases such as Casey and those following it, as including the right to end one's life as an exercise in liberty, was a reductio ad absurdum. And though the Chief Justice didn't say that, he said things that came very close to it. And I think that, building now on what my colleague Professor Lanctot said, it's decisions like that that allow me to continue to regard our Constitution as a contribution to our nation's greatness.
That's great. I would just pick up Professor Moreland's comment, just stand up for Marbury and McCullen, which remind us first in Marbury, establishing that it is emphatically the province and the duty of the courts to declare what the law is. And then McCulloch, I just love the line, we must never forget it's a Constitution we're expounding. But we talk about these other four cases, which all depend on what the court did back then, and I think it is sort of the baseline on which we build, that we do have the courts in this country that have such a prominent role, and the exercise of interpreting the Constitution, quite a challenge. I think you could throw an issue to the five of us right now to try to resolve, and we'd have five different well-reasoned opinions, and it is a Constitution we're expounding, and exactly what it means is a great challenge to figure out. Let me ask another question. I'll go start with Professor Brennan, since he was the last in this part. Tell me your favorite, or if not your favorite, a notable justice we should think about.
Since I knew this question was coming, I had a little time to think about it, and my knee-jerk response would have been Justice Scalia, but I would have had to qualify that in many ways. In many ways, those who've had me in class know. So given the occasion to think about it for a few days, I settled on Justice Cardozo. Justice Cardozo was named to the Supreme Court in 1932. Cardozo was the second Jewish man named to the court. He was a Democrat, but he was nominated by President Herbert Hoover. And most of what we associate with the reasons for considering Cardozo a great have to do with his long, I think, 17-year performance on the Supreme Judicial Court, or rather the Court of Appeals of New York. But he also wrote landmark opinions as a justice on the Supreme Court, where he served for just about 6 years. He died early at 68. And one of the great decisions, opinions by Justice Cardozo in the Supreme Court is Palco against Connecticut, which gives us our implicit in the concept of ordered liberty test for adjudicating due process of law under the 5th and 14th Amendments. And my reason for focusing on Cardozo as a great is that I think he exemplifies maybe best an understanding of how the judicial mind in the common law model functions first, and second, articulates itself in the tradition I also associate with the second Justice Harlan later, and more recently, though less exceptionally so, Justice Souter.
Well, I too bounced around some ideas in my head. Of course, it's hard not to immediately say in response to this John Marshall as the sort of Tom Brady of the Supreme Court, greatest of all time. And I also thought about going early 20th century obscure with either Mahlon Pitney or William Howard Taft. But I thought I'd take it up to the present moment, or the near present moment, and say William Rehnquist. I think it's hard, especially now, to imagine how in 1971, when Justice Rehnquist was nominated to the court by President Nixon, that the debate in constitutional law in the light of the Warren Court looked very different than it does today. And obviously people will disagree about whether that's a good thing or a bad thing. But that the trajectory of the Warren Court was in a particular direction. And it was almost unimaginable that that trajectory and that way of framing the debate about the nature of interpreting the Constitution could change. And it changed for a variety of reasons, but it changed mostly, I think, because of the nomination of William Rehnquist, who was famously the Lone Ranger on the court in the 1970s, often dissenting on his own, often concurring on his own. I have a friend who clerked for Justice Marshall, Thurgood Marshall, shortly after Rehnquist had joined the court, and he said that right from the start, Rehnquist exercised this outsized influence because he was not only remarkably gifted as a legal intellect, but he also knew how to use the power of his pen and the power of persuasion to shape the court. And it wasn't really until he was joined about a decade later by his Stanford Law School friend, Justice O'Connor, and then in the 1980s by Justice Scalia, that he started to have other members of the court who agreed with the way in which he wanted to shape the debate about the interpretation of the Constitution. And then in 1986, he's nominated to become Chief Justice, and he kind of transitions into a whole new role, and by any account was a very successful Chief Justice, much beloved by his colleagues, even his colleagues who disagreed with him on issues. And I think that especially in the areas of criminal procedure, federalism, and the Establishment Clause, it's hard to overstate the influence that Justice and then Chief Justice Rehnquist had. I should say I obviously don't agree with everything. He was a little pro-government in matters of freedom of speech and criminal law in ways that showed through. But I do think that he's someone who now, 13 years on from his death, I think is worth remembering for his I think his outsized and salutary influence.
So I'm glad I'm not preempted when I say Justice Scalia, and the reason I would say Justice Scalia is not because I necessarily agree with all that he has said, because I have certainly written extensively taking issue with some of his positions that he staked out as a jurist. But Justice Scalia, I think, exercised an outsized influence on the court's jurisprudence, and I think in part having been a law professor and having engaged somewhat more systematically with issues of the separation of powers as an administrative law scholar when he came to the bench, I think he came not so under-theorized as maybe some of the other justices who would take things on a more piecemeal basis. I've read many times his essay, A Matter of Interpretation, with his interlocutors, and he engages intelligently with them. I think that Scalia is often misunderstood. I think in terms of pens on the court, he, along with Robert Jackson, have two of the most memorable pens on the court. It's their one-liners that we come to remember. It's hard to forget his dissent in Morrison versus Olson. I think that is maybe a testament to his persuasive powers. I think that the court comes around to recognizing that he was right, and he ends up, I think, getting his way substantially sub silencio, overruling Morrison versus Olson years later in a case that you don't read about, Edmund versus United States. I think Scalia's role as an organizer in the Federalist Society, as a faculty member at the University of Chicago, was tremendously important. I mean, he's definitely a justice you need to engage with to understand the latter half of the latter part of the 20th century in American con law.
Well, I knew I wasn't going to be preempted by any of these guys, so my narrowing down process was this. There have been 109 men to sit on the court and 4 women. So I started with the 4 women. And I'm a great admirer of Ruth Bader Ginsburg, but I think that history is going to look back at her groundbreaking career as an advocate for women's rights, less than her career on the court, although her career on the court has been honorable and substantial and more of a voice in recent years. I think she, like Thurgood Marshall, had 2 parts of her career, and the Supreme Court almost, in some ways, reduced her ability to accomplish what she wanted to do, much as Marshall. So I'm going with O'Connor, even though Sandra Day O'Connor and I don't necessarily share ideology. I'm a big admirer of Sandra Day O'Connor. I graduated from law school in 1981. We were the last class when we graduated in May of 1981 to attend law school under an all-male Supreme Court, because when I graduated from the Supreme Court, from law school, there had not yet been a woman on the Supreme Court. Justice O'Connor joined the court in October of 1981, confirmed unanimously, which of course happens all the time. One of the things I found very admirable about Justice O'Connor was she had overcome a lot of difficulties, as many women in her generation did, the few who went to law school. She did attend the Stanford Law School. According to documentaries, she and Rehnquist actually dated in law school briefly. Nothing serious, of course. But William Rehnquist graduated first from the Stanford Law School and got a fine job when he walked out. Sandra Day O'Connor graduated 3rd in her class at Stanford Law School and could not get a job. As anything other than a legal secretary. She ended up volunteering for a government office for a while to prove herself, and she landed on her feet eventually. But her early career was very similar to that of Justice Ginsburg, in terms of both women going through law school in the 50s, not being able to get a job. O'Connor has been quoted many times as saying that it was very important to her that she do a very good job on the Supreme Court, because she said it was very flattering to be asked to be the first to be something, but she did not want to be the last. And so even though she certainly was qualified, like anyone else, to be on the court, she had a great deal of concern that she work at least as hard as everyone else. I'm not going to single out any of her opinions. I guess I'll say this, and this really is my perspective on her, and I guess it's my perspective on the court, is she's been criticized for not having a grand theory. She once said in an opinion she didn't really believe in a grand unified theory, and I love her for that. That's not cool for common law professors to say that you don't like the theory, but I don't, because I don't believe in it. I actually don't think that most cases are actually are decided on the basis of theory. What O'Connor brought to the court, for better or for worse, and in my view for better, was trying to resolve problems in a pragmatic way and trying to work within the court to garner solutions that would provide guidance to the lower courts and provide guidance to the public. And sometimes she succeeded at that middle ground, sometimes she didn't. But I thought she brought a real intelligence to that, and of course the same reverence for the Constitution and love of our country that the justices all hold. So I'll have an extra piece of birthday cake for the Constitution tonight for Justice O'Connor.
Excellent. And I would say one of my thoughts was one of the other recent nominees or justices, one of the four women, Elena Kagan, because she was a law school dean at one point in her career, so that makes her a favorite. I would also just add to the list Justice Brennan for his, I think, very clear articulation of the importance of the First Amendment in our society, not just a static view of how it allows for us to speak in a limited sense, but really what it means to have free speech in a society, and how much that means to all of us. So I'll keep my comments brief to keep it moving to my colleagues here. And you've got the microphone in your hand, Professor Samahon, and the last question for the group is, what's your favorite part of the Constitution?
Well, for me, it's the preamble of the Constitution. I think it's the statement of our aspirations as a people, and it's also, I think, a recognition that this is an open and unfinished project. Certainly, it is a more perfect union than what the Articles of Confederation were, but it also recognizes that the document is not our perfect Constitution that only gives us right answers. It is a legal document, and many of the founders had some reservations about the compromises that had to be struck for this document to become law. And I think, in particular, the part of the preamble that I find to be particularly moving and interesting is this idea of an intergenerational trust. That the point of the document is to secure for us, this generation, liberty, but also for a future generation. And that might require constitutional entrenchment and yet sort of allowing the process of revision to occur under Article 5.
I saw you pulled out your pocket Constitution.
My pocket
so
Constitution, yeah. Just
we
just
all
to
have
refresh
them.
my memory. So again, I think there's some great obvious answers. The Reconstruction Amendments, the 13th, 14th, and 15th Amendments, both for the substantive provisions at the time of Reconstruction, and also, of course, for their role in the 20th century in incorporating parts of the Bill of Rights against the states. I also have to give a shout out to the free speech and free exercise and establishment provisions of the First Amendment, directing a center here that focuses partly on free speech and freedom of religion concerns. But again, not maybe terribly obscure, but answer is the Supremacy Clause in conjunction with the arising under clause of Article 3. And I say that because I think, as a friend of mine put it, before the Constitution of the United States, sovereigns resolved their disputes through force and through armed conflict. And for sovereigns, which the states were, and in some sense still are, to adopt a constitution that provided for a supreme law of the land and for, under Article 3, under the arising under provision, for reasoned adjudication in law of their disputes and of the disputes between their citizens, I think was and is a remarkable advance in constitutional governance and in Western politics. And so, so my candidate is the Supremacy Clause, which, as I say, I think it conjoined here for this purpose with the arising under clause of Article 3, which again is another reason to celebrate the system of law that we have today, and why we have, why it's important that we have schools of law where people understand what reasoned adjudication in times of conflict, and we've always lived in times of conflict, but what reasoned adjudication and deliberation about how disputes should be resolved through reason, not by force, is yet another reason to celebrate what happened here in Philadelphia.
Professor Samahon said a moment ago that he was happy that he hadn't been preempted with respect to Justice Scalia, but having introduced the concept of preemption into the discussion, I'm also going to vote for the preamble because I'm not preempted in as much as my reasons for choosing it, though they overlap with Tuan's, are very different. We are by nature equal, but we are also by nature purposive animals. And it's been said that statutory interpretation can be understood as the art of proliferating a purpose. But I think more broadly, our Constitution is the purposeful product of purposive animals. And it's our equality in being at least rudimentarily capable of being purposive animals that allows us to come together in the dignified, deliberate way so nicely described by Michael Moreland to form a more perfect union that I think ennobles and emboldens this experiment in democratic living. And so whenever I approach issues, particular issues of constitutional interpretation, I can do so intelligently, I think, or I hope, in light of the fact that the document didn't drop from the sky. It's not to be interpreted, as I sometimes say in class, as a message in a bottle, but as the imperfect creation of purposive beings who identified noble purposes to be pursued by those trying to reach reasoned, careful resolution of disputes important to the parties, but also to the nation and to the world. And so I would single out the aspirations to justice and to welfare as what attaches my loyalty to the Constitution. And though those concepts don't have, by nature of the Constitution itself, very easily specified payoff in individual cases. But if the overall enterprise is, I think, to continue to capture our worthy devotion, it has to be because justice and welfare are demonstrable parts of the aspiration and achievement.
Well, it's hard to follow up on the eloquence of my colleagues. It's a little known fact that Professor Brennan, when he was in high school, was actually in a rock band called Purposive Animals. Just in case he hasn't mentioned it in class before. So now that I've totally destroyed the mood, well, so I took the same approach to the Constitution that I took to the justices, which is I combed the Constitution for any mention of women, and the closest I got was the 19th Amendment, and so I'm going to pick the 19th Amendment, which gave women the right to vote. You know, I was in high school, I was in 9th grade, a very long time ago, back in 1970. My high school civics professor told the class a mnemonic device for remembering the 19th Amendment. He said, you can remember the 19th Amendment because it gave ninnies the right to vote. And I have to say that this will surprise you, that even at my youthful age, I took great issue with him describing the 19th Amendment as giving ninnies the right to vote. And I'm sure that my hand shot up and I gave him a piece of my feeble little teenage mind, went home and told my mother, who wasn't too happy about that mnemonic device. Unfortunately, I've always remembered it that way, which is really why you shouldn't tell little kids those things. Different times back then. But nevertheless, I'm serious about highlighting the 19th Amendment for a moment, and that is because generations of women struggled mightily to have themselves included in the promise of the Constitution, the promise that's included in the preamble that we all revere. The promise in the Constitution was denied to women for a very long time. The struggle began in 1848, formally in Seneca Falls after the Civil War. Women's suffragists tried to get women to the vote at the same time that the vote was being given to newly freed African Americans. They were unsuccessful. They were told to wait their turn. They waited another 50 plus years for their turn, another couple of generations of women. Only one woman who was present at the 1848 Women's Rights Convention actually lived to cast a vote in a presidential election in 1920, and she was really, really old. Susan B. Anthony never lawfully voted. She had a good time illegally voting. And so I do think it's important to remember that our Constitution is an unfinished promise, and that there are generations who have struggled to make our Constitution live up to that promise. And I want to give a particular call out to the women who came before us. A lot of the women faculty have been talking this year about making this the year of the women at Villanova Law School, and shining a spotlight on women here in a way that we maybe haven't done before. And I think for a lot of reasons in society, a spotlight is being shined on women and their role. And so I think it's important that 19th Amendment gave me a role under the Constitution. And I think that our Constitution has been greatest for us when we've struggled to live up to it rather than sidestep it, as I said earlier. And so I'll give a shout out to Susan B. Anthony and Elizabeth Cady Stanton and Alice Paul and the thousands of women who got us the right to vote.
So, you know, every comment was just talking about aspiration in some form. You know, aspiration to justice. You use the term aspirational. I certainly think the preamble, as we talk about forming a more perfect union, is exactly when Professor Moreland and Professor Lanctot talk about 13th, 14th, 15th, 19th Amendments. It is how we were born imperfectly and we remain imperfect, but we can always try to be better, which is, I think, goes to Professor Samahon, in addition to the purpose of animals line, which I will always remember. Professor Samahon speaking about an intergenerational trust. And that's, to me, so important. And that's, frankly, I think why you are here as students and faculty and staff in this place, is that we are engaged in this. And that's what's so very exciting to me, is that the Constitution does ask and expect us to keep working on it. Now, I see it is 43 past. I guess if there are any questions, we can do a couple quick questions if anyone has any. Any theories or ideas, or want to talk about your favorite justice or case or part of the Constitution? Well, I would say if not, oh yes, go ahead. So the question, I don't know if everyone could hear, the question is there a pending constitutional crisis in light of Robert Mueller's ongoing investigation? Anyone want to try that one?
Yes.
No other answers? Okay, that's...
Well, the Constitution is, you know, a lot of it is, we think of course, these individual rights provisions a lot, the First Amendment, 14th Amendment, Of course, a lot of the Constitution is addressed to questions of institutional design, right, and checks and balances, all that kind of thing. And the question is, can I guess, in the background of what you're saying with regard to the Mueller investigation, I mean, what will the Constitution say, what will the courts, which will have to resolve these issues, say about, for example, presidential indictment? Professor Samahon mentioned the Nixon tapes case with regard to the power of subpoenas with regard to presidential records and the like. And I guess I'd say we don't know, right? And that there is the device of impeachment. There's a lot of interest right now, scholarly interest about impeachment, new book from Michael Gerhardt of North Carolina, which I commend to people, and some posts online by Mike Paulson from St. Thomas about the constitutionality of impeachment. Impeachment is kind of the, it's sort of the last resort that the system has provided for these kinds of questions. And so I guess I'm just saying I don't think we're in a constitutional crisis yet, because right now we've got, the system is working, and let's hope that no one precipitates one by forcing questions that I don't think the Constitution is well designed to answer.
I'd maybe offer a qualified yes, and I think it's yes, but not for the reason you think. I don't think it's just a question of Trump. I think that over the last several presidencies, that we have continued to see a trend of growing power in the executive over time, and with fewer opportunities to meaningfully check the president. And so I think this is going to become a growing concern, and if it doesn't come to a head during the Trump administration, then it will come to a head in some future presidency. We have an executive who is not meaningfully politically checked, but at a presidential election, and because Confederates control at least two chambers of the Congress, and so you see a dampening of the separation of powers. Do we have to rely on partisanship to have any kind of checking function? I mean, the members of the House and the Senate don't seem to be as concerned with their institutional roles. I mean, we can change this around too. We could talk about, a blue president with a blue Congress. It's the same issue. The 22nd Amendment makes it so that you really only have one presidential election in which you can really sanction a president if you don't like them at the electoral, at the voting box. Barring that, you hope that the president has the best interests of his party at mind in a second term, so that he doesn't completely go off the rails. But in a situation with Mr. Trump, where he sort of hijacked, perhaps with elements of the party more than willing to have him hijack the party, it's not clear to me that he's going to be particularly moderated by concerns about the Republican Party's future. So I think it is a concern, and we will have some, important questions raised that will need answering. And I'm hoping one of them is not about the capacity to indict and prosecute, a sitting president of the United States. So, yes, qualified.
I'll second Professor Samahon's qualified yes, but as before, for somewhat different, though overlapping reasons. And also take the occasion to advertise the John F. Scarpa Conference to be held here on Friday. This is the 13th annual Scarpa Conference. I've arranged every one of the 13, and this Friday, the featured speaker is Adrian Vermeule, professor of constitutional law at Harvard. You can get information about it on the law school website. I mention it in this context because one of the themes of the book that's the focus of this Friday's conference is what Vermeule calls separation of powers, but one could say more generally, constitutionalism without idolatry. And I think that the impending crisis, if you want to call it that, like others, our forebears witnessed, invite us to think about the Constitution, as has been said before, as an unfinished project, that the successful completion of which at any moment requires certain virtues of the people participating in it, not private virtues, but those virtues that allow them to participate well as purposive animals in this particular system. And we shouldn't, I think, be disillusioned by the strange intentions that emerge, but allow this to be an opportunity to specify the traits of character that are necessary if we're going to have a dignified, fair, just solution to the problems, the successful solution of which the continuation of this constitutional republic depends on.
I'll elaborate only slightly, is that in my view, if you stripped away the Mueller investigation completely, we would still be in constitutional crisis when the president is widely viewed within his White House by people in his own party as well as outside as not being in control of his own government. And so I think that the reports that are coming out and have for some time about the way the presidency is operating with unelected members of the executive branch making decisions, concealing them from the president, taking papers off the desk and so on. I won't rehearse all the things that have been reported. And the widespread view that this is known throughout the so-called elites in Washington, and yet a blind eye is being turned to it, would be extraordinarily problematic under our Constitution without the Mueller investigation. And so I do think we are at an extremely unusual and quite dangerous time in our nation's history. Red or blue, whoever the president is, this is not the way to run the country, and I don't think our founding fathers would think that this is what they intended with the Constitution.
So I guess with that, that moment that we're discussing of whether we're in a constitutional crisis, I would just turn it back on everybody. I guess we do have to wrap it up. I think the biggest concern is I think we're in a constitutional crisis when good people don't do anything in that context. I think there's a lot of failure to act and failure to engage, and that's your obligation. The faculty members here try to teach, and ultimately all of you students, and I'll particularly put on the students, as you go forward, it is your obligation to carry this Constitution forward, to help us form a more perfect union, to help us through any crises, constitutional or otherwise, that arise. I thank my colleagues for their time. I thank all of you for your commitment to being here today, and happy birthday to the Constitution.